The Santa Barbara supervisorial staff set up a meeting for Friday, September 30th with supervisorial staff, Chumash County Parks, and the sending SYCSD to have what they indicated as an on-site meeting for Sandy Park and Chumash Museum. I sent directors Redfern and Van Pelt invitations to attend that meeting because the park has been part of the municipal services review discussion.
Thank you. Okay, do we have a report from legal counsel?
I have no report tonight.
Secretary Treasurer report, Ms. Berry?
No report.
Okay, and committees. I know that Director Redfern and I met regarding the redistricting process and had an opportunity to speak with the person or the people that we voted to have do the redistricting work for us. And it was a really well-run meeting. I was further impressed by the people we chose. We had a very detailed agenda and stuck to it. So I have a sense that they're going to be very efficient. And so this process should go smoothly. Do you have anything you would like to add, Director Redfern?
No, I thought it went well for a beginning meeting.
Okay, and any other committee meetings that anyone would like to report on at this time?
Just a reminder on the 28th of this month that Director Redfern and Director Van Pelt will be speaking with LAFCO representatives about some of the latent powers that we've discussed in the past.
I look forward to hearing about that. That's good. Okay, so now we have consent items. We have all received a packet. It's on our website. There may be some hard copies there also, but these are items that are approving minutes, our dashboard of the disbursements for August and part of September. So are there any corrections anyone would like to make? No comment?
I'll make a motion to approve.
Okay, we have a motion. I did have one comment on the minutes. In one place, they're very detailed, naming names, and in another, it's more what I'm used to. So I think it's probably something that could be decided between the general manager or however he wants to handle that. But you get very specific in the record with names of who said what. It can, it should be consistent, whatever it is, put it that way. So we have a motion to approve.
I'll second.
We have a second. So we have a motion from Director Beard to approve the consent agenda. We have a second from Director Paddleport. Could you please do a roll call vote for us?
We have a motion by Director Beard and a second by Director Paddleport to approve the consent agenda as presented. We'll do a roll call vote. Director Redfern.
Aye.
Director Jones.
Aye.
Director Beard.
Aye.
Director Paddleport.
Aye.
Director Van Pelt.
Aye.
Motion passes.
Okay, so the motion passed, and we will then move on to the action items.
Oh, yeah. Sorry.
Yes.
Is there any way we can put down the blinds so we can see everybody's smiling faces?
I think that would be nice.
Much better.
Okay, before I address this first item, just briefly, there was a request made during public comment to rearrange the agenda, and normally we would be open to that. But one of the members of our bargaining team isn't here, so it doesn't make sense to rearrange the schedule of the agenda items. So the first action item is to consider an adoption of resolution 2222, approving an updated conflict of interest And I would like to turn that over to Mr. Battles to explain.
Now, this is something that your board takes a look at every 2 years as a requirement under the requirements of the Fair Political Practices Commission, that every even numbered year you review your conflict of interest code to determine if any amendments are required. An amendment might be required if you'd had a change in your organizational structure, where you have different employees with different responsibilities, such that they are now required to file statements of economic interest, or are no longer required to file those statements. The FPPC also recommends that you update or amend your conflict of interest code if it's been more than 5 years since the last amendment. Generally, changes in the law are not enough to require a change in the conflict of interest code or an updating, because your conflict of interest code simply incorporates by reference the regulations of the Fair Political Practices Commission. So you've adopted a model conflict of interest code that gets automatically updated every time there's a change in the regulations. But even so, when 5 years have gone by, there's a recommendation that you update it. And in addition, the County of Santa Barbara has recommended that there be an update because of the procedures for actually submitting the Form 700, your statements of economic interest. And in the past, those were paper copies, and now there's an e-filing approach. In the past, they're filed with the district, and the district hung on to the originals. Now the originals go with the county. And so the updated code reflects that recommendation by the county regarding the filing procedures. The process is, once you adopt an updated conflict of interest code, it goes to the Board of Supervisors for approval. They're the code reviewing body. That sometimes takes a few months. The last time I did a couple of these for other clients I represent, and when I went to the Board of Supervisors, the county council took a very close look at the disclosure categories. That's an attachment to your code, and took a pretty strong position that the disclosure category should precisely track what's in the code. What the district's disclosure categories do is they're tailored to the particular operations that you have, things that are likely to give rise to a conflict. And that was the case for other agencies that I represent also. But because the county council felt strongly that it should be a model document and they should all look the same, in those prior cases, we went with the county council's recommended language. And so in this case, I went ahead and did the same thing in updating the code to include the disclosure category language. That was what the county council wanted to see a few years ago, the last time I went through this process.
Smart.
It's the path of least resistance.
Yes. No, it was nice to review that in the packet. I think it's always a good idea. But since we're required, it is done. And I'm sure you will let us know and update us when it gets put on the agenda with the county for approval.
Yes.
Okay, and were there any other items in your report regarding conflict of interest, or any questions about conflict of interest? No clarification needed from the board? Okay, at this time, I would like to ask if the public has any comment on our our conflict of interest.
I can't hear you.
It's difficult to hear.
Ms. Ivy, would you like to move up front?
Well, I'd like to be accommodating to where I could hear without being put on the spot up front.
I agree. We'll wait for the secretary to be able to help. She's been looking into that for you.
It's like a thing that tries to find lost devices and you push this button.
Sorry, I'm not sure if Wendy was able to hear that.
No, I'm sorry.
Oh.
I'm trying to get the phone number for Zoom because people are saying they're getting kicked off. So they want to call in.
Kicked off.
Yeah.
Yeah, I see that a lot of people have made it in. It shows 22 participants. But to address Ms. Ivy's comment, she has repeatedly asked that accommodations be made so she could hear during the meeting. And I know that on our agenda, it says that she should contact you 3 days before the meeting to make accommodations. And it appeared to me that we were trying to get some closed caption going on the screen.
Yes, and it worked when I tested it, and now it's not working, and I don't know why.
Okay, so is there consensus from the board then that we will direct staff to further work on that?
Are you willing to take like 30, one of the concerns was the messing with it to try to fix on the screen would disconnect it. And you didn't want to do that while you're having the thing, but if you're willing to take like 30 seconds to risk it, and then because like without, then we can try it.
What is the risk?
Just that the camera would disconnect and people on Zoom wouldn't be able to hear you. So if I did that while you were talking about something important, that would be a problem. But if you just like pause for 30 seconds, you go to the settings menu and see if you turned on. It wasn't certain it would disconnect the camera, causing people to not be able to hear you while you were talking about something important.
Is that reasonable?
We can recess.
For 30 seconds?
Oh, yeah, why don't we take a 2-minute recess? Do you think that's enough? And if it's not done in 2 minutes, then staff has another month to work on getting
I would
it.
say 5 minutes.
5 minutes, okay with me, Karen.
Okay,
Mr.
Director
Jones, I'm
Van
okay.
Pelt says it's all right. Mr. Battles, what do you think we should do?
I think it should be a motion and a second and a vote to recess. And then the chair can state the length of the recess. And people on Zoom can hear that. If they're temporarily off, they'll understand why.
Okay.
I'll
That's
make that
fine.
motion, Director Jones, of a 5-minute recess.
Okay, we have a motion for a 5-minute recess from Director Van Pelt. Is there a second?
I'll second.
Director Beard has seconded it. So roll call vote.
Okay, so we have a motion by Director Van Pelt and a second by Director Beard to hold a 5-minute recess. We'll do a roll call vote. Director Redfern.
Aye.
Director Jones.
Aye.
Director Van Pelt.
Aye.
Director Paddleford.
Aye.
Director Beard.
Aye.
Motion passes.
And just to restate, we're taking a 5-minute break so we can get the closed caption up to accommodate anyone who's having difficulty hearing. We're in recess now.
I can hear the Zoom. I can't hear you guys. Evidently, you've increased the sound on the Zoom because I can hear Van Pelt good. I just can't hear you guys talking.
There isn't much really many on this.
Well, there was when I did it, so
Pick up their comments here. It seems like we're on Zoom, so it should.
You can't really see it either. The audio is blocking it.
I would talk to our secretary. I'm saying that the suggestion should probably be directed toward you since you're going to be the one who implements it, or Mr. Dreisler.
Yes, so this device does not seem to have an accessibilities menu under settings, which is what it said to do there, nor is there anything about it under the settings inside of Zoom. So I'm not certain if this device actually is capable of presenting.
okay, so if I'm logging,
That's
okay, so when I did it before, I went into the Zoom account.
Yeah, you might have to turn it on and leave it,
And
but
I
there's
did.
also turning it on.
Well,
And you
and
saw
then-
you saw it here, you only saw it here.
No, and then on that laptop, there was a toggle switch that you just hit to close caption. And you just, like, the meeting was going and you just,
And it's not, and that button.
and that button was not appearing on there.
Is that computer logged in to the Zoom account that is associated with the meeting?
Yes. And so now I just logged in on my phone. And if you go to, I see, I don't know if it will do it on a phone.
No.
The meeting settings here, I can
We
see.
have
closed
just
captioning.
the instructions.
So
aren't being
closed
followed
caption
now.
is turned on.
Yeah.
So
And I
that's
didn't
where
have
that-
the
that
camera,
should
I
come
didn't
from
have the
that,
camera or the
not
TV
top
hooked
down,
up to
we're
it. It
assuming
was just
a
the
responsibility that is.
laptop.
Okay.
So have you ever seen this camera present closed captioning?
No,
Okay, I just don't, it doesn't seem like it supports it, because there's no mechanism to turn it on.
okay.
There's no, the accessibility menu that says that you normally do things like Android for it. It seems like that's not the thing. It also, though, has come up that apparently the issue is that you need to talk about it, I guess, as opposed to people on Zoom. That seems like it's solved, because this won't actually close caption you anything. So,
But they're logged into Zoom and Zoom is recording their voices. Why wouldn't Zoom?
oh, I guess because the camera, no, because the audio is going in the camera. I don't think Zoom ever closed captions you. It's closed captions from other parties that are connected here.
What I would like to do is end the recess and remind everyone that if you need accommodations, that you contact the secretary 3 days in advance, and that she will, that's part of her responsibility, and she will see what she can do to reasonably accommodate.
A couple of things, and the board can speak much more loudly until we've got the accommodation in place. We can move everybody up so that the audience can hear better.
Right, I don't want to single any person out, and whether it's in meeting minutes or sitting in a chair. This is the public, and I don't want to single anyone out. I don't have a problem speaking loudly. Director Van Pelt, I agree, was coming through loud and clear. So let us come back from recess. The 5 minutes are up, so I am calling the meeting back to order at 5:54 p.m. And we will do our best to speak loudly and articulate what we're saying, but just for future reference for everyone, the policy on the agenda, it's hard to read. I have a vision problem. But contact the appropriate staff member and they will work through channels and make it happen for you. Okay, and with that, then we will move on to action item B, and that is a discussion and update on sewer line soil subsidence, I like to call it. Is that the,
I don't.
I don't know if you guys said anything when I was talking to Jay, but did you vote on the resolution?
oh, I'm sorry, the conflict of interest. I got off track there. I apologize. So do I have a motion to adopt the conflict of interest?
I make the motion.
Okay, so we have a motion, and is there a second?
I'll second it.
Director Paddleford has seconded the motion to accept the revised conflict of interest statement. So with that, I would like a roll call vote.
Okay, we have a motion by Director Redfern and a second by Director Paddleford to adopt resolution 22-22, approving the updated conflict of interest code. We'll do a roll call vote. Director Redfern.
Aye.
Director Jones.
Aye.
Director Beard.
Aye.
Director Paddleford.
Aye.
Director Van Pelt. Did he get booted off?
His name is there. He may not have realized that we came back. And when you say booted off, can you explain to me what's happening?
Well, they're saying that they're getting kicked off the Zoom call, whether it's the internet connection. I mean, it would only be the internet connection, so.
Well, just to be clear, nobody is kicking anybody off of anything.
No.
If there's a technical difficulty, once again, I would ask for consensus to direct staff to
It could be on
correct
there.
it. Yes, but we have a responsibility to make sure it's not on our end, so staff can consult.
So how do we know which one to take?
Oh,
Okay, so for the people who are getting kicked off the Zoom call, they can call into 1-669-444-8255. 9171. And that will put them in Zoom by audio. And the meeting ID number is 841-7998-5467. You'll have to enter that in after you dial the phone number, and then the passcode is 1070.
You might want to repeat that again for everybody.
Although with one change, and that would be the people who are unable or finding themselves unable to participate. Because when you say kicked off, I don't think that's a fair characterization.
So for the people that are not able to dial in through Zoom, they need to call 1-669-444-9171. They need to put in the meeting ID code of 841-7998-5467 with a passcode 1070.
Okay, thank you. Now, we were in the middle of a vote, correct?
Yeah.
So Director Van Pelt has not had an opportunity to vote. And it was on a motion to approve the conflict of interest statement.
So we'll just mark him absent?
No,
No,
he's
he's
sitting
not.
Oh,
there.
he is? Oh.
Yeah,
Did you hear the motion?
I did hear the motion and I'm a yes. Vote to approve.
And passes?
Okay, so we have passed the updated conflict of interest motion, and we will move on to action item C, authorization of signers on mechanics money
Wait, what
market.
about
trading.
item B?
Oh, I don't want to say the word subsidence. It sounds a lot like a movie that was an adventure. So the subsidence investigation techniques, and for that, I would like our general manager, Mr. Dreisler, to fill us in on that.
That was the subsidence picture, I think.
Very close.
So this is the sewer project, soil subsidence. At the last meeting, I did a presentation that had some graphics that showed a few places where we had some areas of concern. At that point, we were about 2/3 done with the SOPR project. And we have the last third to do. In that last third, we did not discover any areas of concern, and that was mostly on the San Jacoda property. And at the same time we were doing that, we also met with the project manager, David Kerr, and we met with Kelly Robinson from the Geo Solutions. And we also, or at least I reviewed some of the district engineers' information that he presented at a previous meeting, but actually before I was general manager, but he had some significant information to share with us. With David Kerr, our project manager, he talked about a couple of different items, but the main thing he was interested in is trying to get the soils engineer here to talk to us and look at our SOPR project and give some advice. So Kelly Robinson came out and met with Craig and myself, and we had good conversation. She was interested in the SOPR project and was impressed by the idea of going down that path. I did ask her after our conversations if she wouldn't mind presenting a letter to us based on the information she had on site and based on the information that she had from doing the project. So attached to this is RFI #1, trench compaction action considerations. I did try to add what I thought was the most significant piece of information from her letter, although the letter's there to reach her conclusions. But she believed that the trench backfill was subject to a significant storm event that resulted in saturation of the surface over a short period, which also included the groundwater, which we talked about before. And this resulted in the consolidation of some previously compacted materials. Therefore, additional settlement of trench backfill materials is not anticipated. She also discussed about the information that she gave us previously. I think the previous general manager was here. There was a report of the field density test that showed that the compaction in every instance was 95% or better. If there's any questions, I'm happy to entertain them at this time.
Do any of the directors have any questions or need for clarification?
So you're saying she believes it was 95% convection?
Well, the test that they did during the construction process, there's some information here that was a report of field density test. And they did 23 or 24, 25 different locations during the course of the construction. And all of the recompaction of the soil that they removed to install the sewer line was 95% or better. And the requirement in this non-road bed area was 90%, and they reached 95% plus in every area that they did a compaction test.
I have a question, Mr. Dreisler. Did I hear the word that they believe that they got 95%, or is it documented in all of their sampling that they have achieved 95%?
That's a good question. It's documented, and I'm happy to share that report as well. That shows that it was 95% of that.
Yeah, if you could. And do they have a diagram of the actual sampling of along the trench?
Yes, they do. Would you like me to send that to you?
Yeah, just to view so that we can lay eyes on. I think myself, and I'm sure there's other board members that would love to inspect a diagram or at least a plot points to understand where they achieve this 95% compaction rating.
Yes. Yep. I have that here tonight, but I'll be sure and send you a copy of that via email.
Thank you, Mr. Dreisler.
Are there any other questions? Yes, Dr. Redfern.
So what we're looking at here is something that they did before we had any fall. These tests were taken right after construction. Is that correct?
Well, this
is not a new test.
Right. It's not, well, the detail you're looking at is the detail the contractors followed to refill the
But
area.
they haven't done any further testing. All we have done is they filled the trench with water as per the board's instruction.
Right.
Correct.
And one of the things, we did have Kelly come out to talk to us about doing some recompaction, which they would be totally happy to do, but she, at least I think, indicated here that the compaction probably wasn't.
But we got the whole thing to fall in several places without a major rain. So I find what she's saying is to be wrong.
So you would like us to do some compaction tests in some of the areas that we found?
I would say that would be a wise thing to do, being we're about to take it on as a finished project, which it's not. And we should be really sure of what we're taking on, because November's nearly here and we're still screwing around with it.
Yeah.
I have a question. Did were they able to determine movement of the pipe?
I know that I talked to Kilborn, the engineer from Cannon, and they did camera the pipe, and there was no movement in the pipe during that.
I'd be really surprised.
What was that? What did you say?
I'd be really surprised, shocked if the pipe moved actually.
So
I think we should do a compaction test, and has the construction company, were they asked to extend the warranty?
No. So no, they have not been asked to do that. The areas that we outlined as areas of concern at the last meeting, we showed the graphics for that project. We would do one compaction sample in each of those areas that we recognized last month.
I think didn't you have some areas that fell a couple of feet?
Yeah, there was one area near the end of the barn on the second piece of property.
How long was that fall?
We had 48 inches, but one of the things.
It was 48 inches, but how long did it run in the trench line?
It was about 15 feet, and I'm going from memory, so don't hold me to that, but that's what I'm thinking. Maybe.
I think you should have at least two of them.
So maybe we should just think about that. We should do one every 6 feet, maybe in the area, just in case I didn't.
Yeah, several feet into where it fell, and then somewhere.
Because that's what we're looking for, probably some additional data points to to see what that soil compaction was in that area.
Because the rain incident that we're talking about isn't that big for San Ynez. I mean, when it rains here, it can really rain. And it was a rain, yeah, but it wasn't anything special.
So they have been put on notice that we've had a failure, or the construction company.
Failures past, they haven't been notified other than the time they came back out here, but I definitely tell
I
them,
think they
I'll tell
should
them
be.
what we're doing now.
Yeah, I think they should be notified, that we've tested this area and it's falling again.
I would like to add to Mr. Dreisler that from what I hear from the other board members, if there's just a lack of confidence right now in this, the conclusion of this project. And so I think we're quite united that we need additional reassurances that as this project concludes that we're not going to be hung out to dry, and our constituents and the people we represent.
With that, I think that clarifies for the board. I would like to see if there are any comments from people, members of the public right now on this topic. And I don't see anyone on Zoom. So with that, then I would ask the board to give direction to staff. There's not a specific vote recommended here, but it sounds like we would like to table this. That this remains an open issue for us, and we would like to revisit perhaps getting some more data. Is that right?
I have good directions, and I can read back what I've written down here. One's to send this additional report to Bradley, to Director Van Pelt, to do some compaction tests in the area of concern, possibly at 6 feet on center in the area that we're looking at, to notify the contractor that we are doing this, that we did some due diligence in our process, and to notify them that there's a chance there could be something that comes out of this recompaction test. And it sounds like in general, the directors are looking for some more confidence and some additional reassurance that the work that the specialty construction did is going to last through the next winter.
Right. And
Through
probably,
all winners, not the next one, all of them. There's
But-
livestock in there. Livestock's expensive. Livestock steps into a trench and breaks a leg. We could be responsible for some expensive animals.
so I think that I agree with what you read back, but also additional data is what we're looking for when we want to document what we've done and what we do.
Director Jones, continue on this topic briefly, because we've spent many meetings speaking about this over the course of the last 12 months plus. What legal recourse, we have counsel here in the meeting and on Zoom, what legal recourse would CSD have, our CSD setting as, if indeed we weren't satisfied with specialty construction and in their compaction test? Do we go down that? I'm not saying we go down that road now, but it'd be very, I think, wise if we start understanding what the next step is, if indeed we keep having this kind of stalemate, because this has gone on for numerous months now. We've all been aware of this for numerous months, and it seems like we're kicking the can down the road and not really getting to what to me is really the core of the issue, and it's really getting out there and addressing it. So I guess I turn over to you, Director Jones, or in our council, Rick, and Mr. Dreisler. What legal recourse do we have, or how do we handle this if we don't get what we want?
Well, I would like Mr. Battles and Mr. Dreisler to respond to that. For me, I think we have gotten a lot of data, and I understand Frank's point, but I also know that this is something that is a legal issue, so we should defer to the people who are going to be working on it.
Right, so under the construction contract, we have a specialty Specialty is required to construct the project in accordance with the plans and specifications in a good workmanlike manner. If we can identify a construction defect, then Specialty is responsible for correcting it at its expense during the 1-year warranty period. So Specialty constructed the project and they gave us a 1-year warranty. Contract basically says if there's a problem with it, if you can identify a defect in the way we constructed the project within the first year, then we're contractually bound to correct it. And so I think where we are in the process is trying to determine if there is a defect and document it. Initially, a defect was identified, whether it was the subsidence, and then that was corrected. So we're trying to confirm that there aren't other latent defects that are not, that you can't see on the surface, so that it doesn't come to light. Those defects don't come to light after the warranty period has expired. We do have legal recourse under the terms of the contract if we can identify a defect within that 1-year warranty period.
We've already had the experts say there is no defects after the first fall that happened during the rain event, that everything else was great. And if I hadn't kept pushing, we wouldn't know that we had these other areas. I think we pretty much know that the project isn't completed correctly. I don't think they have a lot to complete it correctly, but I think they should get the compaction correct through everybody's property. We already know it's not correct.
When Mr. Kilborn was here answering our questions, he said something that was interesting to me, and that is they completed the project as agreed to. So that's probably going to be a sticking point. The county asked that there be a slurry to
That was in
stabilize.
the roadway.
That was
Right, in the road, and that was the county road. On the private property, we didn't ask for that.
You don't need it. It just is a matter of bringing it up in small lifts and compacting it correctly. And that's where they skipped a step. They brought it up to either too fast or they didn't bother with the compaction. They brought it up in too big a lift. The lift is like, could be 12 inches or 6 inches, and you compact it with a compactor. A lot of times they get in a rush and they put in 2 feet and then they try to compact that and they don't get the correct compaction. So I'm finding all these tests kind of suspicious, knowing that the line fell with just water.
Okay, so the line did fall? That was my question.
Just the compaction of the line
Oh,
fell, not
okay.
the
Not the pipe.
pipe,
Okay.
just the top compaction. So they had a drop of what, 48 inches? What was
Yeah,
it?
that was the longest, 48.
With the probe, we went 48 inches down into the ground,
I think
Right.
one was 19 inches.
which we couldn't recreate when it was dry, but you did recreate it when it was wet.
Right. But didn't you also have soil fall in the line also where you soaked? Where soil actually dropped before you probed?
No.
Everything stayed
Yeah.
complete on the top.
Yeah, the only places that we discovered areas of concerns, we had a probe that we were using
able
along
to
the way.
drop
and
it
that probe went further down and those few.
And how long is that, what's that probe? What you said that it was 2 feet or 3 feet long? So we don't really know how far the probe could have actually gone.
Right, it could have gone down further, which sort of leads toward, how deep do we do the compaction tests?
But if you have 90 or 95% compaction, there's no way that probe is doing that.
Right.
So I have an
Okay.
additional question, Director Jones, then for Mr. Battles. If we found a defect in this process but we found it, do we have to go get independent? Do we have to now bring an independent evaluator into this to prove our point? Because it sounds like we're in a stalemate. And my concern, as it should be a concern of all of ours and our constituents, is that this kind of moves closer towards the point that our warranty runs out, and now we're pressed or compressed for time. And I definitely don't want to get to the last minute to where we're pushed to find a resolution. And it sounds like we, as of now, don't have one, and the clock's ticking. So do we consider bringing up an independent evaluator to look at this, to protect, our stake and our constituents?
Do we have an independent evaluation at this point? It's not the contractors. Kelly, what was the name?
Kelly Robinson,
Yeah.
Geo Solutions.
Geo Solutions was retained by the district.
They did
to
the
do
work
the-
during the project.
Yeah. And that was the district's independent investigator, not someone that the contractor hired. So we do have our own expert. It sounds like the board may not have confidence in the expert's conclusions. And, it is a situation, as you point out, we don't want to run out of time. We suspect that there's a problem with the way the project was completed, but we can't go to the contractor and insist that they do repair work or, additional work in the absence of some evidence that there is a problem. We have one investigator or one our expert saying it appears that there's not a problem, but there's still reasons for concern. And so I think what the board needs to do is, to the extent those concerns still exist, is find the evidence to support those concerns. And then we take that evidence to the contractor and request that they comply with that they honor the warranty.
And clarify just this question, Mr. Battles and Mr. Dreisler's. My understanding is that this compaction report, though, was after the initial construction. And we've already proven that with our saturation test that there is already issues. As Director Redfern pointed out, these compaction tests weren't taken after this saturation test, right? These were taken during the initial construction in the original backfill process.
That's correct. They were taken during the course of construction.
So I think herein lies. So we're going back to square one. Is that even if she seems to be independent, either as Director Redfern pointed out, right? They kind of skipped some steps and they hurriedly did it, and they achieved some compaction, but they did it. They maybe did it incorrectly. So now we're stuck with a situation that we have to go relook at. So maybe it's advisable to the board that we have to hire at our expense another compaction expert to go in there and to evaluate the project, or we don't have anything with specialty construction because we just have reports that were based upon the initial compaction tests. And again, correct me if I'm wrong, but they doesn't seem to be true.
So at this point, Director Redfern, do you think that it would be the wise thing to do to hire an independent person who has not yet worked on this project and get that? Or should we do that along with documenting to specialty, the original, the people who did the work, that we still have some concerns? And
I would let them know we have some concerns. And I think the independent person doing the compaction test at several levels going down would be wise. Whether they can get it all in one tube and can check the compaction all the way up, I don't know. But we'd want to know that there's good compaction down to the pipe.
My general sense is that a company like Geo Solutions would do an adequate compaction test, and they're not going to report out something different than what they found if we give them specific areas to do this. I don't think most scientists and or soils engineers would report something that was different than what was there. So I have a preference that we use somebody that's really familiar with the project, but we could still do it. And
I don't have a preference, but I do think that we should give them good, clear instructions of what we want so that there's no differences when it's all done.
And I tend to agree with Director Redfern. I go back to your comment, Director Redfern, is is that we have livestock. And so all we need is a few broken limbs on some animals. And we would pay for quite quickly any independent evaluator in these soil compaction tests. So I would rather get ahead of the problem, as we're trying to do in these circumstances, and direct our staff to move as quickly as forward with identifying an independent soil compaction expert and hiring them, and then providing clear instruction, because we just had a saturation test, so we really know the areas of concern. We have all the data and the diagrams in front of us. Now we just need people to go there and to do a little further analysis.
Is 2 weeks a reasonable time frame to get somebody out to do it? And then that would also give staff plenty of time to document and be prepared at our next regular meeting to report.
You know, I wouldn't be against, we're doing the 2 tests there. What if we did 3 random ones?
I wrote that down already.
Yeah,
I think that makes sense too.
yeah, it's hit or miss, but, and then we know the area that we know we might have a problem with.
Let me contact Geosolutions. They've been very responsive so far, and Kelly Robinson, who came out pretty quickly. I mean, it was probably, I contacted her on Thursday and she was out on a Tuesday. So I feel like they're going to be responsible and they understand the circumstances, and I'll try to get that information as quickly as we can.
Okay.
Does that satisfy you, Director Van Pelt? Is that a reasonable time frame?
You're on mute.
Might be on mute.
Sorry about that. Yes, it does satisfy me, and I'm also looking though for other board members. I don't want this to be a Director Van Pelt, pushed initiative. I think, I would like to know that the other directors are on board with this, because this seems to be a concern that, frankly, hasn't gone away, and we do know that there's liability for the CSD, RCSD on the table still.
I don't think that you are the primary driver of this. I think we all have concerns, and I appreciate your expertise in problem solving and Director Redfern's familiarity with the terrain here. So I think it's really good. Some people, myself included, might not have initially thought, wow, there are horses on that property. And then when that just throws everything in a different light. So no, I think there's consensus here.
Yeah.
I see that Director Beard and Director Paddlecourt agree that we should pursue this.
Wonderful. Thank you, Mr. Dreisler and Mr. Battles, and I think it's satisfactory. I don't have much more to comment on this subject.
Okay, and so it seems like we have consensus and we can move on. We got our report, and I think that it's very clear that this is something that is going to be at the top of the priority list. Okay. And now,
I was just going to remind you that I know you've probably been doing it, but look at the wait list and hands in the air.
yeah, I don't see any hands in the air. I don't know if you're more familiar with me, but is there something that I'm missing here? That's asking. Oh, hold it. Where's the chat? I'm scared. I saw somebody else. Oh, okay. It's just Jay with the information. Okay, I would like to thank Jay Freeman for putting up how to get in on the chat, but I don't see any other hands. Yes.
Would you like a public comment on this?
Yes.
Okay.
I asked for it before we got into
I
the
know,
weeds,
now
but
that
yes.
discussion's got me thinking, so Chairman Shai, District Employee. So a 95% compaction is absolutely fabulous compaction. In a rain event, even with 95%, this could still happen. And if you then go and saturate the ground again, it actually will lift it, right? And you'll get pump in the ground. So if you try to compact it when it's saturated, you'll pump it. And it actually brings it up and it reduces compaction by doing that. So if you saturate the ground and then stick a probe into it, that's not an accurate compaction test.
Right.
Right? So there is no saturation test. It's all about dry compaction. right, with a percent moisture. Well, as soon as you exceed that percent moisture, your compaction tests go out the window. So when you saturate the ground and then try to do a test on it, it's inaccurate, 100% inaccurate. So you can do some more compaction tests, but you don't want to do it after you've saturated the ground. It needs to be completely dry. So anyways, I just want to say a 95 in this industry, a 95% compaction test is wonderful. And even with a 95% in a rain event, it can still drop down. It could be a gopher hole, squirrel hole, a little void around the pipe that could cause this huge sinkage within a trench. So just wanted to say, I know you guys had the crew go out and saturate the ground and then run a probe down and stuff. That doesn't tell you anything, actually. So just want to say that. Thanks.
Thank you. Okay, with that, we can move on to the next topic. And just as a reminder, what we're doing is introducing the topic. We are then getting the staff report, giving directors an opportunity to clarify and ask questions. Then I will ask for the public if they have any comments. And then after your comments, then the board will choose to or not to take action depending on what it is. But I appreciate your knowledge. Thank you.
Just try that.
Me too. So we will go then to action item 7C, authorization of signers on mechanics money market bank account. And for that, I will turn it over to our secretary, Wendy Berry.
All right, on November 17th, 2021, resolution 21-11, authorizing Mechanics Bank money market account to stay open at Mechanics Bank. And with the change in the GM and the change with the board member, we need to redo the signature card for that bank account. So their requirement for a new signature card is a minute order. And attached to the staff report is the minute order that would need to be approved by your board to add the new signers to the account.
Are there any questions or clarification needed?
Is this just our regular bank account? This is not any of the money market stuff or anything?
It's a money market account that draws interest, but we have it over there in case we need access to cash for some reason.
Okay.
Okay, are there any public comments on this? At this time, then I would like to ask for a motion.
I'll make that motion.
Okay, and that will be to authorize signers on the Mechanics Money Market Bank account. So with that, we have a motion from Director Beard. Is there a second?
I'll second.
Director Paddlecourt has made the second. So can you please take a roll call vote?
Okay, so we have a motion by Director Beard and a second by Director Paddlecourt to authorize to approve the draft minute order authorizing current board members and 2 staff members to sign on the Mechanics Bank money market account. We'll do a roll call vote. Director Redfern.
Aye.
Director Jones.
Aye.
Director Beard.
Aye.
Director Paddlecourt.
Aye.
Director Van Pelt.
Aye.
Motion passes.
Okay, so it's passed. And we will get the information from Secretary Berry and sign the card. So number 7, D, action item, adoption of resolution 2220, authorizing remote teleconference meeting for the district's legislative bodies pursuant to Government Code 54955E. So I will turn that over to Mr. Battles.
This is the standard resolution that you've adopted in the past to continue extending your option to have remote meetings. And so if you want to continue to have that option, then this is the resolution that you would adopt as you have in the past.
Are there any questions or clarification from directors?
Nope.
Public comment? Yes, Mr. Lee.
Jeff Lee, Teamsters 986. So I've seen this, and what I've kind of seen this to be is related to COVID, if I'm not mistaken. Certainly, I don't believe that something like this should be used to abuse this by being able to remote in as a board member from different locations, such as different states. I don't think that that's the intent of this. So if there's not some sort of COVID-related concern for this, I don't know why it's continuing to be extended, other than to have and allow board members that have been elected that should be here in person to go on their personal endeavors and not attend these meetings in person. I think that's an abuse of what this is, and I think that if that's the case, and the only concern with authorizing this is to allow that to happen, I don't think it should continue to get renewed. That's it.
Thank you. There is a public comment, Ms. Ivy. Yeah, are you using the timer? Excuse me, Mr. Dreigler, do you have the timer?
I have a question about the Zoom meetings, because after the August 17th meeting, I got a lot of calls from my neighbors that were out on vacation. And one personal friend lives 6 months here in the Valley and 6 months in Canada. And they called and told me that they were waiting for 33 minutes in Canada, trying to get in and to give a comment, a public comment. So my question is, does this Zoom meeting identify the party, or does it identify where they're calling from? And therefore, if you see that it's not in our area, it's not recognized. I just don't know how people on Zoom get their public comment in. You know, I don't understand that. So I do think that if you're going to continue to have the Zoom meetings, there's got to be a way for the people that's traveling, that's part of this community, if they've taken time out to stop and get on Zoom to participate, that they should be able to make a public comment. Thank you.
Thank you. Are there any other public comments? I do not see any here either. Okay,
I was gonna say, I think in general, the public comments at this point are usually specific to the topic that we're discussing.
right, and we're discussing Zoom reauthorization.
Right.
So I think both of those were appropriate. Okay, and so this would be a time, if someone would like to make a motion to approve the resolution.
I make a motion to continue the resolution.
Okay, Director Paddleport has made a motion to adopt resolution 22-20. Is there anyone who will second it?
I will.
Okay, so we have a motion to approve the resolution to authorize remote teleconferencing of our meetings from Director Paddleport, a second from Director Van Pelt. Can we please have a vote?
We have a motion by Director Paddleport and a second by Director Van Pelt to adopt resolution 22-20, authorizing remote teleconference meetings of the district's legislative bodies pursuant to Government Code 54953E. We'll do a roll call vote. Director Redfern.
Aye.
Director Jones.
Aye.
Director Beard.
Aye.
Director Paddleport.
Aye.
Director Van Pelt.
Aye.
Motion passes.
Okay, so we have adopted the resolution for teleconferencing. Now we'll move on to 7E, which is a discussion and possible approval of resolution 22-21, authorizing the investment of monies into the FDIC insured certificate deposits. And so I'm not sure who's doing the staff report. I assume that it's Ms. Berry.
I'll start off.
Okay.
I'll
very
start
good.
off. But I wanted to make sure Wendy was a significant part of this process, and she'll be the one implementing. So if she hears me say something that's not accurate, please jump in at any time. This is a continuation from our previous meeting, and we were talking a little bit about the difference in what you might get in terms of interest. And so we tried to add a table on the back here that shows just in a very simple term, really just the first year, what would happen with the interest versus being in just the Five-Star Bank. So you look at this in the Five-Star Bank with the entire amount, principal amount now, would earn us about $56,482. And if you look at, if we have the $200,000 at 3 different rates, we'd earn about $70,115. So there's about a $13,000 difference. One of the things that happens when we started looking at this is after the first year, you start to get into lots of assumptions that must be made to determine the total interest earned accurately. So we really stopped at the 12-month period here, but we still show that there's a $13,633 additional interest in that first year. So I think staff's recommendation at this time is investing the $200,000 each in the 12, 18, and 24. And when that 12-month period comes up a year from now, that we'll come back and look at how the interest actually accrued, and that we'll consider additional options at that time.
Okay. Do any directors have questions or need clarification on what's been presented?
No.
Not for
Okay.
me.
I would now invite members of the public to comment. I do not see anyone wanting to comment on this item, and I do not see any hands raised online.
Thanks for looking. We were just talking about making sure there's nobody.
Yeah, it's busy up there. It's kind of hard to tell what I'm looking at. Okay, well, very good then. So at this time, what we would need would be a motion to pass the resolution.
I'll make that motion
Okay, Director Beard has made a motion.
to, well, for the the $70,000, three different levels.
Okay, so you're making a motion to proceed as explained by our general manager.
Yes.
Okay, and is there a second to that motion?
I'll second you.
Okay, we have the motion made by Director Beard, and it was seconded by Director Redfern to approve Resolution 2221 that would authorize the investment of monies into FDIC insured certificate of deposits. So if we could have a roll call vote.
Okay, we'll do we have a motion by Director Beard and a second by Director Redford to approve Resolution 22-21, resolution of the Board of Directors of the San Ynez Community Services District, authorize investments of monies into the FDIC insured certificate of deposits. We'll do a roll call vote. Director Redford.
Aye.
Director Jones.
Aye.
Director Beard.
Aye.
Director Paddleton.
Aye.
Director Van Pelt.
Aye.
Motion passes.
Okay. So now we will move on to item F, which is discussion and action relating to Resolution 2223, approving changes to the terms and conditions of employment of employees represented by Teamsters Union Local 966. So,
986,
excuse me?
986.
Oh, sorry. Local number 986. So let's get the staff report.
Director Jones, can you check to see if Nate Kowalski is attempting to join us by Zoom? I just got a text indicating that he was
Oh,
gonna
there he
sign on
is.
now.
Yes, I see him. Can you hear us all right?
Yes, I can hear you. Good evening.
Okay. Mr. Kowalski is part of our bargaining team. So we have just brought forward and are ready for the staff report. Are you going to be giving the staff report? Mr. Battles?
I certainly can. It's a relatively brief staff report. What you have in your agenda packet is a resolution which would provide for the implementation of the district's last best and final offer. The resolution sets forth the history of the negotiations, just so that's documented, and discusses the process for renegotiating or extending the contracts that expired in June of 2020. The resolution recites the fact that there were 10 meetings and a full day mediation, and then the resolution is presented for your board's consideration. What it would accomplish if you adopt it is for the last best and final offer would be implemented as soon as reasonably feasible. And with respect to the compensation components of that, it would mean at the next pay schedule or the next pay period. And I'm not sure exactly where we fall on the pay periods.
Okay, and is there anything that you would like to add additionally, Mr. Kowalski?
Not really. Director Jones, the resolution really speaks for itself.
Okay, and are there any questions or clarification from any directors? See none, so now we will go to public comments. And once again, I ask everyone to keep their comments to 3 minutes. We'll use the timer. And I also would ask that people are respectful, avoid personal attacks, vulgar language, anything disrespectful. So,
I'll try.
So you're speaking first, Mr. Lee?
Yes, I have a speaker still there.
Okay.
It's right here.
Oh, thank you. I didn't know. Thanks a lot.
Before I start, I just ask that you make sure that you guys are continuing to check Zoom for people that are waiting in the waiting room. They want to speak. My name is Jeff Lee. I'm the business representative for Teamsters Local 86. I represent the operators and administrative members of the St. Inez Community Service District. I'm here tonight in response to the district's consideration to adopt resolution 22-23, which would impose St. Inez Community Service District's last best and final offer on the employees. Imposing this would result in a great loss of income and create an economic hardship on every member that I represent here at the district, who I believe are all seated here with us today. The benefit was originally approved by the board of directors back in 2005, and it has been in place for 17 years. The district has not conveyed any type of economic hardship that would warrant this type of severe act. And to my knowledge, the budget has already been approved, which includes this benefit. The question I want to ask you is why? Why do you feel this is a good idea? Are you interested in making your employees suffer? Do you want them to lose their homes, their cars, their way of life? Who in their right mind believes that imposing a $2,000 per month reduction in wages for these members during the largest economic downturn, at least in my lifetime, is a good idea? I urge you to stop this ridiculousness and go back to the table and make a reasonable offer. An offer that can be legitimately accepted, that won't result in the emotional and economic hardship that you're pushing with this offer right now. Thank you.
Thank you. Are there other public speakers?
Yes.
Yes, please.
Director Jones, can I have Director Jones, I'd like to ask a clarification question. Can I get
Probably not a good idea.
Hold it. I lost you, Director Redfern. Or not Redfern, excuse me.
Director
Van
Van Pelt?
Yes, okay.
Yeah, just trying to get a clarification on definition of wages on that. I just want to understand the definition of wages. The term wages were used, and I want to understand Mr. Lee's definition on wages.
Mr. Kowalski, maybe you could answer that.
Well, wages are compensation. I think the broader term is compensation. And certainly the parties can debate the proposals that were made at the table. I would reiterate what's in the resolution, which is that there was 12 months of bargaining, there were 10 meetings, there was a full day mediation. And in the district's view, the district reached an impasse. Obviously, the union is not happy about it. But we think the record speaks for itself. I don't know that it's fruitful to engage in debate about the back and forth of the proposals or to debate semantics in terms of wages, compensation, benefits. That's really not, in my view, a fruitful exercise for a public meeting. I would note that the Teamsters have already filed 2 unfair labor practices against the district, claiming that the district engaged in bad faith bargaining. And that again, in my view, the proposals speak for themselves, and the rest of this is to some degree rhetoric. So that's what I would say, Director Jones. And
Okay, I appreciate that.
I'm happy
Sorry.
to respond if you guys want to.
No, what I would like to
You
do,
can have the podium back.
we're doing 3 minutes. We have a lot of people. There are hands up. I can see when hands are up, and right now I count at least 4 people in the waiting room, or not waiting room, on Zoom that would like to speak. So go ahead, Jeremy.
I'll make it quick. My name is Jeremy Shia, Union Stewart, here to speak on behalf of the employees represented within the operations unit. There's a term in collective bargaining called regressive bargaining. I'll read the definition to you. A specific form of bad faith bargaining when one side moves backwards, offering less of a proposal than they previously offered. The board's last best and final proposal is definitely a regressing proposal and is considered to be bad faith bargaining. The board's last best and final proposal is also missing a specific item that was previously agreed upon. And when you admit previously agreed upon offers on a last best and final, that is also considered bad faith bargaining. You guys made this proposal in mediation. It still takes effect. You cannot go backwards on this. So even if the union refuses one of your proposals, you cannot go backwards on it from that. Your last best and final proposal must at least be status quo or better than that previous proposal. And it's obviously that this last best and final, it is not. It is not better than that. And now to make matters worse, you're about ready to vote on this last best and final offer that is possibly an illegal document. It is unlawful. It is proven that it is bargaining in bad faith. It is regressing. I just provided you the proof right there. Your last best and final. Look at it. Look at your resolution. It is less than that. Your resolution states it, what you had offered. Now your last best and final is less than that. You cannot do that. It's against the law. It's bad faith bargaining. The definition says it right there. It is a regressive proposal. With that being said, the employees do not want unlawful labor practice claims being filed. We don't want more litigation. We want a fair offer where we remain whole and we can come and do our jobs. The board already knows that the employees cannot take on this financial burden. We beat this horse to death already. You know this. You just need to care and not do this to the employees. You can't do it. My recommendation to the board tonight is to vote no on this resolution, or at least table it for now. Let's get back to the negotiations. Make this a real proposal. And I guarantee you, as a union steward, we will strongly take that proposal into consideration. Just let's get back to the table. Okay? One
Thank-
last statement, give me 5 more seconds. Thank you. Director Beard, last board meeting, you said that our union has not done us justice and is hurting us. I believe the shoe is on the other foot here tonight, sir. It is actually your negotiating team that is performing the injustice. It is your team that is participating in bad faith bargaining, offering regressive proposals.
The 3 minutes is up.
Hey,
Thank you.
Director Beard, if I was a board member, I'd fire him.
Are,
You can vote.
are there other people present? I see some people on Zoom. Yes, sir, you may speak.
David Everett, Teamsters Local 986. Didn't have anything prepared, just kind of came to the meeting, wanted to listen to what you had to say. And heard some of what my brothers had to say about it. I don't really have anything prepared, but I just wanted to share a couple things that I saw today. Was compaction test was talked about. And there was some public comment. There was some comment from you that you're concerned about liability, but not about doing the right thing. Okay. And then remote telecom, public comment came in, and you basically disregarded all of this public comment and moved on. Maybe that's how these things would normally work, you know, but I kind of would hope that public comment would actually be included in your thought processes before you pass resolutions. The third one is, I think it's Mr. Kowalski here, mentioned that 12 months of negotiating to eliminate an economic benefit to these workers that they've had for 17 years. And I don't know how you think that your 12 months of bad negotiating could ever, you know, get these folks to agree that they should give up $2,000 a month. That's going to hurt these folks, and you guys know that. And I hope that you take the public comment from me, consider that. Just consider it, okay? And think about what you're doing to just a handful of workers. You're not talking about a whole bunch of people, but these guys do vital work for your community. And you know, they should be, you know, just kept on the same pay, same compensation that they've had over this time. You know, when you talk about time, there is no good time to take away this amount of money, but you're trying to take it away at this period of time when everybody's really hurting. And it shocks me. You guys know that times are tough for people, and things have gotten worse. And I don't think you should be taking money out of their pockets. That's all I have to say. Thank you.
Thank you. Is there anyone else who is here? Yes, Ms. Ivy.
During the August 17th monthly meeting, board meeting, it was suggested that perhaps you should offer that not to affect the current employees, but to take this for the future employees. Leave the status quo for current employed, but any future employees, you would put this in effect. Well, Director Beard was very adamant at that meeting that that had been proposed to the union and rejected. So I told you then at that meeting, I thought we needed to go back to the union. So I contacted Chef Lake and I asked him to confirm that. And he told me that he was in the waiting room on Zoom to come in and give a public comment and to make the statement that that was not true. So I'm conflicted here because I don't know where you got the information that you were so adamant about that this offer had been rejected when the union is saying it was never offered. Now, I'm asking you to reconsider that before you vote, because if you vote for this and do this to the employees, not only are these employees losing, but we're as a community is going to lose because of the lawsuits and the cost that it's going to cost. And I just don't think that we should go down that road to lawsuits and do all this when there is a reasonable thing. It's in the budget. It's been approved. It's not going to hurt us financially. So I don't understand why the board would not want to just leave the status quo for these people that's been here for years, and they've had this benefit for 17 years, and just enforce it for future. I think that's a reasonable offer, and I think you should consider it. Thank you.
Thank you. Is there anyone else who is present that would like to speak?
Hello, I'm Linda Small. I'm the executive director for the Standing Nest Chamber of Commerce. I just wanted to come and hear what all of this was about. It just seems like $2,000 is a lot of money to lose per month. The staff, it's a small community. Something like this kind of gets out. I don't know why. I think the biggest question I have is why. That's it. Why you would be cutting the salaries at this time. And employees are so hard to find these days in different industries. And you've got a staff of very well educated, staff that knows what they're doing, who've been here for quite a number of years.
Thank you. Is there anyone else who is present in the room who would like to make a public comment?
My name is Wendy Berry, and I'm the secretary treasurer for the district. And I am represented by the union, and I am a union steward. At the August 17th meeting, Director Beer stated that that proposal was offered to keep the employees whole. Obviously, there's a confusion because I am the only person in my bargaining unit, and I can guarantee you if that was offered, I would have jumped all over it. I ask what the reason is why the board is so compelled to take this cash in lieu option away from the employees. It was approved by the board of directors April 15th, 2005. It's been available to the employees for 17 years. The employees aren't breaking any rules or policies by taking this cash in lieu. I quote from the section 125 policy. The purpose of this plan is to allow employees of the San Ynez Community Services District and other participating employers to choose between cash compensation and health care coverage under medical plans sponsored by the San Ynez Community Services District. The district is not in a financial hardship. It will put approximately $270,000 in reserves at the end of this fiscal year. The budget for the fiscal year was approved by the board of directors at the August 17th meeting, which includes this health insurance allowance and a 5% cost of living. It's not because the district has to pay a portion of the city's plant upgrade, because the district's costs of the upgrade have been calculated in this rate study and planned in for the 10-year CIP that was adopted by the board. The rate study was completed and approved and includes current costs and future costs. You want to do your fiscal duty for this district while hiring new employees is a costly expense, and it will be hard to replace the knowledge and the history that the employees have. And in times where qualified employees are hard to find, it would be very, very difficult. As an example, the last position we filled, we received 5 applications and 4 of them were referrals from one employee. The other one was an application that was just submitted. I asked, would you like to have a $2,000 cut in pay? Would you do the same job, put forth the same effort, and be as dedicated if your employer did this to you? By approving this resolution tonight, your board will be imposing a financial and emotional hardship on each and every one of your employees. It proves you don't care or value the employees or their well-being. I urge you to vote no or go back into negotiations and offer to keep the current employees whole.
Thank you. Is there anyone else who is present that would like to comment?
I'm Craig Kapner. I've been here 23, going on 24 years. After I said my piece at the podium last August 17th there, Director Beard said, your employees unit has not done you justice. We offered a step down so it would not financially impact you. Your union threw it out, would not do it. We are the only ones have given anything. If I was in your union, I would fire you. After contacting my union steward, who attended each and every negotiation, informed me that no specific offer from the negotiations committee, it didn't happen. That wasn't true. Now, you're not on the committee, so you're going by information that you're being told. I think you're getting some bad information from your committee members here. And if that's going on, if you guys can't tell the right story to each other, you guys have no business directing a CSD and making policy. That's ridiculous. How can the district continue to function if the board cannot be truthful with one another or its employees, voting and making policy based on misinformation and mistruths? Is it a personal agenda that one or more board members are trying to see fulfilled? Is saving this dollar amount each year so critical that the end justifies the means? If I was on the board, I would investigate the matter further, and then I would ask for resignations, or I'd leave the board myself. I wouldn't work with people you couldn't trust if you're getting bad information and there's deliberate lying going on. I'm finding it increasingly difficult to work here under this kind of direction and supervision from a board of directors who have no regard for the employees here, taking a huge cut like this. And it seems like you're misrepresenting information to one another. My plea is go back to the negotiations table and get the story straight. Thank you.
Thank you. Is there anyone else present physically in the room that would like to make a comment before I go to the people on Zoom? I see no hands, so I'm going to start with, okay.
I'm not gonna cuss this time.
And before you start, I would just like to let Katie McShirley know that she will be the next speaker.
I want to, emphasize on what Wendy said. There's not a lot of people coming in lining up to do this work, this lousy work. There's not people who dream of working in sewers, right? This is a vocation. This is something that we dedicate our life, put our life on the line, and we have a motto here that we say we don't get paid for what we know, but the responsibility. We get called on holidays, we get called on all of these occasions, grocery shopping, whatever it is. We get paid for that. To take away $2,000 really does hit. It hurts financially, right? It hurts. This is how we support our family. This is what we build our lifestyle around. Like I mentioned in the other meeting, right? So when we take away those things, we're now forced, or this job loses its lure. This job loses its attraction, right? Apart from the career and the trait and everything, it's also the good money that we make for the responsibility we have to bear. And that is what we're talking about here, that when you take away all of this stuff, we're fleshing it down, no pun intended, down the toilet, these careers, these things, these opportunities to grow. I see myself here 30 years, 40 years, perhaps one day being a supervisor for you if he ever retires, one day. But when you take all the lure away from this job, who wants to work here? When there's a volatile environment, who wants to work here? There's no one lining up to do this. There's no one lining up saying, hey, I'll take this job. No one is doing it. No one wants to deal with that pressure. No one wants to deal with these environments. It hurts to see this situation happen. We're not asking for a change. We're asking for things to stay the same. Leave it alone. Go back and talk. Use logic. Use your thoughts and not the emotions. Use reason, because this is not reasonable. When you have to respond several times a night for emergency, and now you're like, damn, how am I gonna put gas in the car if I don't have the same amount of money? If I don't have, I don't get paid by you guys for all this stuff. This comes out of my pocket. The wear and tear on vehicles and all of that stuff. Give me a truck to come and respond to a call that we can't even get that. We can't even get, this is my wear and tear on my vehicle. This is my money, not your guys's. We're the ones rocking here all the time. Just leave it alone. We just want peace. We want to come to work and enjoy it. We don't want to be effed around with it. Just leave it alone. Right? Just leave it alone. That's it. Why ruin it? Why ruin it? I don't understand it. We walk around with 2, 3 phones all the damn time. Leave it alone.
Thank you. Our next speaker will be via Zoom. And the name is Katie, I believe. You may start.
Yes, that's correct. Thank you, President Jones and board members. My name is Katie McShirley, and I'm speaking on behalf of Supervisor Doss Williams from Santa Barbara County. In his role, Supervisor Williams has participated in numerous negotiations with our employees and their representatives. We understand how complicated and challenging these negotiations can be, and understand there are many factors that must be kept in mind to balance directly. Keeping good employees
Yeah, I can't hear. I'm sorry, I can't hear.
Service
Yes,
has never been more critical, as it has become more challenging for board to continue working. Stop my video and try that. Am I coming clearer?
Somewhat, but it's still a little choppy.
Sounds better to me.
Okay, maybe if you could go to someone else and I'll call in through the phone.
We can hear you right now.
Okay, my apologies. I'll start over. Just wanted you to see my face. Okay, thank you, President Jones and board members. My name is Katie McShirley, and I'm speaking on behalf of Santa Barbara County Supervisor Doss Williams. In his role, Supervisor Williams has participated in numerous negotiations with our employees and their representatives. We understand how complicated and challenging these negotiations can be, and understand there are many factors that must be kept in mind to balance obligations to our employees and our constituents. I think it's critical to not see these obligations as mutually exclusive.
It's pretty jumbled.
Rather meeting possible through meeting our obligation to our employees, as they are the ones who serve our constituents directly. Keep critical as it. Go after another commenter.
I don't know. Yes, did you, yeah, let me go ahead and go to the other people who are waiting with their hands up. And then we will
Okay.
come back to you on a landline.
She could call the number that's in the
Okay,
chat.
great. Thank you. My
Okay,
apologies.
yes, in fact. Okay, thank you.
Thank you.
Okay, Daniel Mora. You are next, Mr. Mora, and then after Mr. Mora, we will go to Megan.
Hi, thank you. My name is Daniel Mora with the Central Coast Labor Council. We represent over 75 unions on the Central Coast, including in Santa Ynez. I'm on here just because we're worried and upset about the principle of what can be taking place. As a union organization, we work with dozens of unions across the Central Coast. The fundamental belief of our organization and the members we represent is that collective bargaining is collective. That means that the workers have a seat at the table to bargain with management. No union employer should unilaterally impose contract language or changes to pay and benefits on its employees when they are sitting across the table from you bargaining a contract in good faith. These are members of our community that work here, working hard every day to provide government services for the people of Santa Ynez. We urge this board to go back to the negotiating table and work with your employees on a collective bargaining agreement that is fair and agreed to by your employees. Thank you.
Thank you. Now we will hear from Megan Harmon.
Hello, good evening. My name is Megan Harmon. I'm a member of the Santa Barbara City Council, and I'm speaking to you this evening on behalf of myself only. I appreciate the opportunity to take just a moment to talk to you a little bit about my own experience. I've been in very similar positions to what you all are in this evening, and I think it was what Supervisor Williams was going to say and what you'll probably hear from him. I understand how challenging it can be to try to navigate the incredibly complex world of collective bargaining, to navigate all of the different things that we have to balance as representatives, and frankly, as individuals who have taken oaths to be good stewards for and on behalf of our community. But what I have seen and what has been very true in my own experience is that if we do not prioritize the well-being of our employees, the first to suffer, of course, are those individuals and their families, followed very closely by our constituents. There is a direct correlation with the way that we treat our employees at that bargaining table and the services that our community can come to expect. And that's because what we get when we go to that bargaining table in good faith and prioritize the health and well-being of our employees and their families, what we get is skilled labor. What we get are individuals who understand the value of our city and community systems, and frankly, who believe in those systems and who want to lift up our communities. So I deeply respect the challenging position that we're all in when we have to make these decisions, but I urge you to return to that bargaining table. It's a difficult time, and it's an incredibly difficult time to be finding employees. Let's prioritize the incredible, hardworking, dedicated, skilled workforce we already have. I know that's what I'm trying to do, and I urge you to do the same this evening. And thank you very much for allowing me to share my experience with all of you. Thanks.
Thank you. Now I would like to hear from, we cannot have disruption or we'll have to maintain order. Now is Megan Dietenhofer.
Hi, if you can hear me.
Yes.
Okay. Good evening, Santa Ynez Community Services District. I'm Megan Dietenhofer, 3rd District Supervisor Joan Hartman, Santa Ynez Valley District Representative. Supervisor Hartman is attending a SENCAL board meeting tonight, which is the reason she can't be there herself. As a resident and representative of the 3rd District and as a supporter of union collective bargaining rights, Supervisor Hartman asked me to speak to you tonight in support of the Teamsters represented workers of the Santa Ynez Community Services District. Santa Barbara County works with many different unions to provide labor for a variety of work that the county needs to have done. and the county and the public benefit from good relations between the two organizations. The county has seen very high quality of work from these groups, with a high level of professionalism and workmanship coming from the union members that have been used. In this case, Teamsters families have come to rely on the district's previously negotiated cash in lieu of health benefits allowances that were offered to the workers. While the district and the Teamsters have come to terms on CPI wage increases and other labor matters, elimination of the in lieu of benefits clause translates to a significant reduction in overall wages earned by these employees. Supervisor Hartman recognizes and believes in the work and good faith on both sides negotiating thus far, and hopes there's an amenable solution to the impasse, particularly if there can be one that would not amount to an erosion of benefits and wages earned by these workers. Thank you for your consideration.
Thank you very much. Now we're going to try and go back to Katie, who had the rough connection.
Yes. Hi, everyone. I apologize for the technical difficulties.
Go ahead.
Great. Thank you, President Jones and board members. My name is Katie McShirley, and I am speaking on behalf of Santa Barbara County Supervisor Doss Williams. In his role, Supervisor Williams has participated in numerous negotiations with our employees and their representatives. We understand how complicated and challenging these negotiations can be, and understand there are many factors that must be kept in mind to balance obligations to our employees and our constituents. It's critical to not see these obligations as mutually exclusive, but rather meeting our obligations to our constituents is only possible through meeting our obligation to our employees, as they are the ones who serve our constituents directly. Keeping good employees who provide excellent service has never been more critical, as it has become more challenging to compete in the hiring of new employees. I encourage your board to continue working with your employees and their representatives for the sake of good continued services to your constituents. Thank you.
Thank you. Is there anyone else on Zoom? The two hands I see up have spoken, Megan and Katie. Is there anyone else on Zoom who would like to speak? I see no hands. So with that, any discussion from the board? I see none. So this would be the time that I would ask for a motion.
Director Jones, I do have a question. Is it possible, we have to ask legal counsel, there were some objections to what was revealed last meeting. Does the board have the power to go into a private session to discuss very important matters pertaining to, comments made by board members about negotiating? Is there something that we can do now to address these concerns? And I don't want to necessarily table this because we've spent a long time speaking about it, but I do feel that I would like to speak with our counsel directly in private session about some of these accusations.
No, you can answer that, Mr. Battles. Normally, if we want to do a closed session within the parameters of the Brown Act, we would need to do notice.
Right, it would have to be an agendized item.
Okay.
Okay. Well, then, once again, I am inviting a motion to approve the terms and conditions of employees represented by Teamsters Union Local 986. Do I have a motion to approve?
I'll make that motion.
Okay.
I'll second it.
We have a motion by Director Beard to approve the motion. And we have a second by Director Paddleford.
Okay, we have a motion by Director Beard and a second by Director Pettiford to approve resolution 2223, approving changes to the terms and conditions of employment of employees represented by the Teamsters Union, Local 986. We'll do a roll call vote. Director Redfern?
I don't know what I want to do right now.
Well, we have a motion on the table. So we're voting.
I'm
So-
saying no then.
Okay,
Director Jones?
yes.
Director Beard?
Yes.
Director Pettiford?
Yes.
Director Van Pelt?
Director Van Pelt.
Sorry about that. Aye.
Okay, so a vote has been taken and
Motion passes.
yes, 4-1. Okay, informational items. I will turn that over to our general manager, Mr. Dreisler.
Thanks, Greg. Good job. Gonna be real.
Thank you.
Item 8A, and we received 2 letters from one of our customers, and one was in relationship to disability, and particularly hearing, and the other one was related to some expenses over time that we need to look into, but we're going to continue to instruct all members of the public to contact district staff who's responsible for addressing the needs. And I believe that's bullet item number 7 on our bullet number 5 on our regular board meeting agenda that talks about persons with disabilities. You can read that on your own, but it's basically contacting staff 3 days in advance so we can make sure that we can do that. And the other one is we're going to have staff and legal counsel will review and report a recommendation in a reasonable time frame.
Okay, are there any other informational items? And at this time, I would ask for a motion to adjourn.
A motion to adjourn.
Director Paddleford has made a motion to adjourn. Is there a second?
I'll second that.
Okay, so we have a motion to adjourn by Director Paddleford, a second by Director Beard. Can we please have a roll call?
We have a motion by Director Pettiford and a second by Director Beard to adjourn the meeting at 7:25 p.m. We'll have a roll call vote. Director Redfern?
Aye.
Director Jones?
Aye.
Director Beard?
Aye.
Director Pettiford?
Aye.
Director Van Pelt?
Aye.
Thank you all very much.
Oh.